Much of the common law is truly ancient, and one of the most ancient concepts of all is stare decisis, or the doctrine of precedent. The whole Latin phrase is stare decisis et non quieta movere, which means to stand by decisions and not disturb the undisturbed. In other words, once the courts have made certain judgments about the law, those judgments should be binding on all the later cases with similar circumstances. We follow the precedents. Well, I went on a little quest to find the earliest statements of stare decisis in our written laws. For the first few centuries, while it was clear that stare decisis was being followed, nobody in the court really saw the need to explain that process, or if they did, it wasn't recorded by any of the early court reporters. So the first example we have comes from the year 1584 and the case of Spicer and Spicer as recorded by Sir George Croke. His reports, which were made for his own benefit, weren't published until 1657 and the authoritative version wasn't published until 1791. In Spicer and Spicer, a man had died, leaving his land to his wife for so long as she lived, and so long as she paid £3 a year to one of his sons, Thomas. And then he left his land to another son, Richard, upon her death. But Richard also had to pay Thomas £3 a year. The wife died, and Richard took possession of the land. But there was a question about whether he held the land in his own right to do what he wanted with it, or whether he merely held it for his life, which would have restricted what he could do with it. Now the court found that he owned the land in his own right, but that's not the important bit. The reasoning of the court included the following statement: "Those things which have so often been adjudged ought to be left in peace." The court then followed that statement by listing a number of earlier cases which had established the precedents. So the system of stare decisis, which is practiced in every court in Australia every day of the week, can be traced back at least as far as a case heard nearly 450 years ago. I may be a nerd, but I think that's kind of cool.